The American Journal of International Law. United States armament is dependent in time of war on the right to purchase arms from neutral countries until sufficient war materials can be obtained and prepared in this country. If the principle of the Burton Resolution were adopted by other nations, it might force all nations to accumulate supplies of war materials and tend to increase militarism at home and abroad. The prohibitions in the Burton Resolution are much stricter than those in the Geneva Convention of 1925, which in time of peace allow shipment to governments or their agencies and which in time of war is suspended. At Geneva, the small nations who depend on foreign war supplies appear to have opposed any arrangement which would exclude them from the purchase of arms abroad. The events of the last war were still fresh in their minds. What would have been the situation of Belgium or indeed of Holland as to their military defenses if the purchase of war supplies in other countries had been prohibited? Finally, the Burton Resolution obliterates the distinction long maintained in this country between an exportation of arms as a purely commercial venture and an exportation involving the use of territory as a base of operation. It would place a restriction by municipal law on a trade which international law sanctions. At the same time, it would place a very onerous duty of self-imposed neutrality on the United States, violation of which would not doubt bring charges by the belligerents of laxity or bad faith on the part of this country, particularly if any change in the resolution were made by Congress during the progress of a war in which the United States was neutral. For this reason, it has been suggested that any restriction or control of the kind proposed by the Burton Resolution should be made by the importing country and not by the exporting country. In February 1928, Senator Borah introduced a Senate resolution reading as follows: whereas the rules of maritime law in time of war as codified at the Second Hague Conference and in the Declaration of London were in important respect departed from during the late war, and whereas it is important as a condition of the limitation of armament and of the orderly conduct of international relations that the rules of law as developed in the course of centuries be not left in doubt or uncertainty, and whereas the present chaotic state of maritime law leaving the seas subject to no definite rule save that of force, and commerce to no ultimate protection save that of battle fleets, constitute an incentive for great naval armament. Therefore, be it resolved that the Senate of the United States believe, first, that there should be a restatement and recodification of the rules of law governing the conduct of belligerents and neutrals in war at sea. Second, that the leading maritime powers of the world owe it to the cause of the limitation of armaments and of peace to bring about such restatement and recodification of maritime law. Third, that such restatement and recodification should be brought about if practically possible prior to the meeting of the Conference on Limitation of Armament in 1931. This resolution has a long and significant background. It has its origin in the differences which arose between the United States and Great Britain during the period 1914 until 1917 as to the respective right of belligerents and neutrals in maritime war, culminating finally in the breakdown of the Geneva Conference of 1926 among Great Britain, the United States, and Japan for the limitation of naval armament. It would be most unfortunate if the difference of views as to rules of law were to become irreconcilable, and it is doubtless to prevent such an outcome that the Bora resolution was introduced. The resolution is likely to be debated and probably adopted in connection with the Naval Appropriation Bill to come before the December session of Congress, since the armed neutralities of 1780 and 1800, in which neutral nations forsook armed organized protection for their rights, steady progress had been made by international agreement in limiting belligerent claims to intervene with neutral rights and in enabling neutrals to escape ruination from wars in which they had no part or interest. The Encyclopaedia Britannica correctly remarked, neutrality is the most progressive branch of modern international law. The rapid changes it is undergoing are in fact bringing the state system of the modern world nearer to the realization of the dream of many great writers and thinkers of a community of nations just as much governed by legal methods as any community of civilized men. To this desirable end, the United States has, from the beginning of its history, made the most commendable contribution, forever identified with the names of Washington and Jefferson. This contribution arose from resistance to British enroachment on neutral rights in the wars of 1793, when Britain undertook to prevent American commerce from reaching France on the alleged ground that France was a peculiarly reprehensible nation, that the French government had taken over control of the food supply, and that the entire population was engaged in war. The inference was that all foodstuffs sent to France would thus have a military or combatant destination. The argument Jefferson unequivocally denied. He maintained that reason and usage had established that when two nations go to war, those who choose to live in peace retain their natural right to pursue their agriculture, manufactures, and other ordinary vocation, and to carry the produce of their industry for exchange to all nations, belligerent or neutral as usual, subject to the restriction of not furnishing to either party implements merely of war, commonly known as contraband, nor of carrying anything whatever to a place blockaded. When the British argument was repeated in 1916 with the substitution of Germany for French, it wasn't resisted as effectively as Jefferson had resisted it over 100 years before. The 19th and 20th century had been marked by a steady advance in restraining belligerent claim and giving neutrals an established legal status much along Jeffersonian line. The decision of Lord Stowell and of Marshall had made important contribution to this end, as had later the Declaration of Paris, the two Hague Conferences, and the confirmation of existing law embodied in the Declaration of London. International relations still contemplate the possibility of war. International law, through the development of centuries, has worked out a fairly definite compromise between the two conflicting and irreconcilable claims of the belligerent to stop all trade with his enemies, and of the neutral to continue freely to trade with both belligerents. That compromise, like all adjustment, is founded not on logic but on agreement. Such agreement is the law governing their reciprocal relations, and it cannot legally be departed from by either party. It is built around the principle that the neutral may not furnish direct military aid to either belligerent, but the other trade is free. That principle underlines the rules governing the legal disability of neutrals to trade in contraband or to violate lawful blockades. Thank you.